And that's the nature of your lawsuit, is that's freedom of association based
Correct.
on freedom of association.
Right. We asked, our argument is that this is a First Amendment case, that Act 10 substantially impairs the employee's right to associate together for the purpose of engaging in pursuing matters of mutual interest, including bargaining their wages with their employers, petitioning their government regarding their wages and conditions of employment. And that it treats us, the general employees, differently than it treats other employees, like these so-called public safety employees and bus drivers. And there's no ration, and there's not, and that this distinction is arbitrary, leaving bargaining open to those people but not to the general employees. And because it's our First Amendment rights that are at stake, what are called fundamental rights, in order for the government to impair the exercise of those fundamental rights, it has to have a compelling governmental interest to do so. And then it has to act in a way that has the least impact possible on the exercise of the fundamental rights. So our lawsuit says they've impaired a fundamental right, they've done it, it's being applied arbitrarily, and we've asked for discovery to determine whether or not there's a compelling interest. Well, the other argument, the argument being made in the other lawsuit, the federal lawsuit, the WEAC lawsuit, is they agreed with the defendants that they're only challenging the equal protection, the equal application of the statute, and where you're not arguing that there are fundamental rights involved. All the government has to show is that there's a rational basis for the distinctions it is drawn in this law. But there's an exception there if the even your rational basis or no rational basis, if the purpose for your law is to punish people or basically an illegal reason, then the law is a violation of the Equal Protection Amendment. And so what they did in the WEAC lawsuit, they agreed that they were only challenging equal protection and that the rational basis test applied. But the WEAC and the group involved there argued that the motive was improper. That it was the motive was to punish those who supported the labor organizations that supported the governor, that opposed the governor politically, and to reward those who supported him. And among their evidence, of course, and this is all in the face of the statute. For example, the Capitol Police they have the power of arrest. They wear badges. They carry guns. They do all that kind of stuff. And guess what? They're not public safety employees because they are members of the AFSCME union that oppose the governor. On the other hand, the Milwaukee police officers, and that's another story.
I know, we've heard a little bit about that story, yeah.
Yeah, they have, and because they gave it to the Milwaukee police officers, they had to give it to the WPPA people. They have the right to bargain collectively because they supported, primarily it's the Milwaukee police that supported Walker. So, and that's what Connolly looked at, and he found that in that context, with that background, the law was generally okay, but with respect to the annual certification requirement and the dues checkoff prohibition, there simply was no rational basis. It was clearly punishment. So that's what he held. But he also repeatedly said, if you read his decision, he said, the parties didn't argue this, they didn't argue that. Well, we're arguing that.
Yeah.
That's what we're arguing.
Yeah. So you're stuck in discovery phase?
Well, we're stuck because we asked for discovery and they opposed it, and the magistrate judge agreed with them and said, we're not entitled to discovery. And then and we've appealed that to Judge Conley, who's the district judge. And they also they filed a motion arguing that we had not sufficiently alleged, in our complaint, we had not sufficiently alleged a First Amendment claim. So therefore, we have no First Amendment claim, and with respect to the difference in treatment, because we have not alleged a First Amendment claim, it's only the rational basis test that has to be met, and they've met it.
So has the judge ruled on that yet?
No, he hasn't.
No.
And
So you're waiting for that.
right, that's what we've been waiting for several months now. Months, literally. The last brief
Well, it was filed last summer.
the lawsuit was,
The suit, the original suit.
and the briefs were filed back in December. So we're waiting to hear
So,
regarding
now
this,
Well, we had a trial set for
We-
end of May
but that was
Oh.
canceled now.
recently.
Yes. The judge, at the request of the Justice Department, canceled the trial and scheduled another scheduling conference for the end of May.
So now it's a scheduling conference.
Right. So we're hoping that we'll get a decision by the end of May, because
Maybe we'll need
otherwise,
to schedule discovery at that conference.
right, because otherwise, why have a scheduling conference if there's nothing to schedule?
Yeah.
Presumably, the judge thinks there'll be something to schedule then. At least that's what I'm thinking. But I don't, who knows?
Wow. Interesting times.
Yes. I mean, Judge Conley's a very capable fellow, and I think he's a good fellow. So, and in finding that in the WEAC lawsuit, he found that the prohibition against the dues checkoff, the prohibition of the dues checkoff, and the annual recertification requirement did impair First Amendment rights. He said it. So we're thinking, okay, that's what we're saying.
Right.
I mean, because we specifically have said that. And we've said in addition to that, we've said there are a whole bunch of other things out there that impair our rights.